too.
I mean, I have. I just you're not in an environment not anymore.
Oh, and then one of my, I have two
starts with a
parents
two.
in my room that work with me. And
Much
the one
easier.
one gets off at 3:30, and then the other one has to stay till
All right,
4.
everybody, we are live, so and it is 5:30, so we'll go ahead and get started.
So then
We've
I
got
have
two
to
items
stay.
on the agenda this afternoon. So welcome to the City Council study session for Tuesday, February 17th, 2026. The first item on the agenda is a discussion regarding the Monarch Society grant habitat installation, education, and mural at City Hall. And we have Michelle here to talk about that with us.
Thank you, Mayor and council members. It's so good to see you this evening. I'm very excited because we're on the cusp of spring, so you know that always brings out the hyper Michelle, because we have so many great things. But tonight, I'm really excited to talk to you about this cool partnership that Oklahoma Monarch Society selected Norman to be a part of. It's funded through the Kirkpatrick Foundation, and it includes habitat installation, public education, and public art. So I'm pretty excited to show you this. All right, first though, you know, every time I talk to you, I have to tell you why we're doing what we're doing, right? So let's talk about why this matters. This map that you see on the screen is actually the map of the eastern monarch population migration route. And if you notice something really cool, we're always talking about us being the heartland, but we are the heart of this corridor, right? So what happens in our state actually matters to these pollinators, right? So it's really neat. And monarchs and our other native pollinators are suffering steep declines, right, in population from habitat loss and pesticide use, climate change. All of the things are making them decrease. And they're not just important. Pollinators are not just important ecologically. You know, I like ecology, but it's not just that. It's also agriculturally and economically, right? Because not only is 1 out of every 3 bites of food we eat from pollinators, 80% of our flowering plants depend on pollinators, but also $20 billion annually in US products are created by pollination. So it's a big deal, right? And monarchs are a nice flagship species, because they're highly recognizable. Luckily, all of the pollinator habitat that we install for them, though, feeds our native pollinators too. Native bees, moths, all of the things that we love and need to survive. So let's talk about the partnership. Oklahoma Monarch Society chose only 2 cities in the entire state. Only two. Us, yes, and Edmond. So this is really cool. It's not just here's some money to put in some habitat. Yes, that's part of it, but it's also going to be the public education where we can bring people in. It's going to be the public art where we connect people emotionally to their environmental stewardship. All of these things. But the huge thing is that hopefully these 2 cities can create modules with the Oklahoma Monarch Society that can then be used elsewhere in other cities with other NGOs, with individuals, right? So people can implement this kind of stuff for themselves and we can help everybody. Well, why was Norman chosen? Well, you know why Norman was chosen, right? We have a strong foundation in conservation leadership. If you look across the city, all of the pictures on the bottom are pollinator habitats that we have in our city. We have over 8 cultivated pollinator garden areas, over 22,000 square feet of managed pollinator habitat, and then another 79 acres of natural pollinator habitat. So this grant is not creating something new. It's just adding on to and strengthening what we're already doing. And here's the heart of the project, right? The pollinator gardens at City Hall. Okay, we're looking at over 500 different native species, or 500 different plants across 34 native species, right, in 2 different planting zones. It's also going to have natural elements like mossy boulders and cedar mulch. Cedar mulch and mossy boulders will also provide habitat. But guess what? It also gives it that intentional, well-maintained look as well. So residents will know what it is and what it's for. Here is an actual site plan of where it will be at the front and then also at the north side of City Hall. So we'll have two areas. You'll see from both the aerial and the site photo that it's highly visible, public-facing area. That's intentional. We want this to be a demonstration site for pollinator habitat. There'll be educational signage as well. Here's a list of some of the featured plants. We have plants that have blooms, food, or shelter for the entire seasons, all of the seasons, for the entire year. So spring through fall, obviously not winter, but there'll be habitat support in winter. We have monarch host plants, right? You'll notice that there are 4 different kinds of milkweed up there. That's great, because milkweed is the only plant that the monarch caterpillar can eat. And we have 4 different species, 50 plants over 4 species. We have wildflowers that will produce the nectar, right? When the monarchs come up in the spring, they're here looking for nectar to feed themselves so they can keep on and drop off their babies. And right in the fall is what I was thinking with the nectar. In the spring, they're dropping their babies. But they need those plants to keep going. We also have shrubs. This provides that habitat, but also food for those species that aren't necessarily monarchs. I have a beautyberry bush in my yard, and all kinds of animals come over and eat those berries and also use it as habitat. So it's very exciting. And remember, it's not just the planting, right? We're gonna have educational signage that talks about what the garden is for, why pollinators matter, and will help reinforce that it's an intentional area and it's the way it's supposed to be. We're gonna have community programmings with Oklahoma Monarch Society. So we're gonna do, hands-on activities, presentations, seed giveaways, monarch tagging in the fall, those kinds of things. So we're really gonna try to get that education out there and bring people along with us. And then of course, there's the mural by Oklahoma artist Rick Sinnott. You guys might recognize his work. I'm sure you would. We have several of them in Norman, 2 at least in Norman, one on Natural Grocers and one on our building, right out on Main Street. Sorry. This is just an example. This one is in Wewoka. It will be similar. It will be specific for Norman. Here's the actual monarch mural location. It will be on the Development Center wall facing Gray Street. So again, very public facing, very visible, a great way again to tie people emotionally to environmental stewardship. You see this again as well at the Household Hazardous Waste Facility. If you haven't had a chance to get down there and check out Hazmat, please do. This will be another way. These are 2 more examples of Mr. Sinnott's work. Like I said, we don't have the design yet. But it will be unique for Norman. And here's the timeline. So the planning phase is almost done. We're expecting implementation, so we're gonna start clearing up the beds really soon. We're gonna be planting on April 11th. Why am I telling you that? Come on out and help us. But really, we're gonna use big event help. So OU students are going to get involved. We see community members really getting involved with these kinds of practices so they can get hands-on and learn and also be a part of it, have stake, right? Everything wraps up in the fall, like I said. Monarchs in the Park this year will be at Ruby Grant Park. If everyone remembers this last year, we had a huge showing of monarchs. So let's bring that back, right? And monarch tagging, fingers crossed. That's really something I want to do. Our first event that's scheduled is April 4th. It will be the Native Plant Workshop, and we're having it at the well. So there's another community partner, the Cleveland County, right? Cleveland County Farm Market. That's how you say it. They're partnering with us. I'm looking forward to this huge community collaboration and environmental education event. So, again, this partnership is just expanding on what we're already doing, and it really leans into what our sustainability and resilience goals are. And we really thank you for your support. And we would love it if you would, yes, here's the ask, if you would promote and advertise and participate in some of the activities that we will have coming up. And with that, I can answer any questions. I also have Megan Phelan, who actually is the plant designer. Yes, thank you, Megan. And Michelle Chow, who is also instrumental in this. So with that, I'll take any questions.
Councilmember Hinkle?
Did you say butterfly tagging?
Yes.
What is?
Yes, let me do. So what we would do, citizen science, you catch monarchs, and you place a little tag on them that sends an RFID,
really?
sends out a thing, and so you can track your monarchs as they make their way in the migration. It's a great way for scientists to find out how much of the population survived. Yeah, it's gonna be fun. All right.
Councilor Rico.
I assume it's gonna be all drought tolerant native plant species, so that probably means
Correct.
there's no maintenance going forward. Other than the occasional maybe cleaning up and tidying, but no big water budget, no big, replanting budget.
Correct.
Yeah.
After the first 2 years, it takes about 2 years for native plants to really get established. You're absolutely right. Watering, maintenance, everything will go way down. There will be no spraying. That's one of the big things about the monarchs, right? No spraying. No spraying will be in the area, no fertilizer, no chemicals.
Okay, any other questions from Councilmember Bowser?
I don't have a question. I just wanted to commend you on this because I love it and it's amazing. And every time you have monarchs in the park, my kids love it.
Oh, yes, that makes me happy. And these are echinacea. These are a wildflower.
Councilmember Dixon?
No, I was just.
Any other questions or comments from Michelle?
Keep up the good work.
All right, yeah.
All right, thanks, guys.
Thank you, Michelle, appreciate it.
Yeah, sure.
All right, item number 2 is a discussion about the Oklahoma Supreme Court's decision in Allison et al. Versus McCoy Post et al. Case number DF-122946 and submission of ordinance number 0-2425-2 to the registered voters of the city, or alternatively repealing ordinance number 0-2425-2. And we have our legal counsel here to lead us in this discussion.
And just to give you an overview, first we'll talk a little bit about the Supreme Court's decision in that case that you mentioned, Allison et al. Versus McCoy Post et al. From earlier last week. We'll talk about the possibility of submitting that ordinance, establishing those TIF districts to the voters. And then we'll talk a little bit about some of what we think might be the circumstances if council were to decide to repeal that ordinance. All right, Allison versus McCoy, Supreme Court case number DF-122946. The parties to that case were the proponents were Pamela Sue McCoy Post, Paul Thomas Accaroli, Richard Sondog, and then the protestants were Kyle Allison, Vernon McCowan Jr., David Nimmo, and Philip Quinn. February 21st, 2025, that case was Judge Virgin. The issue was surrounding the sufficiency of that initiative petition, referendum petition. There were a number of arguments made by the protestants. On February 21st, 2025, Judge Jeff Virgin, our district court judge, ruled that the gist contained in the petition was insufficient, and therefore holding that it was not sufficient to essentially compel council to submit that ordinance to a vote of the people. The proponents appealed Judge Virgin's ruling. February 3rd, 2026, the Oklahoma Supreme Court affirmed the district court's ruling. When that happens, there's a couple of things that need to happen before that decision actually becomes final. One of them is what's called a petition for rehearing. The Oklahoma Supreme Court rules allow a party that did not prevail in an action to file a petition for rehearing. By court rule, you've got 20 days to file your petition for rehearing, which would make a petition for rehearing in that case due on February 23rd, 2026, so next Monday. I have not heard one way or the other. I don't know whether the parties intend, you don't have to file a petition for rehearing. That's just something you've got discretion to do, and I don't know whether the proponents intend to do that or not, but if they do, that deadline is February 23rd. If a petition for rehearing is not filed, or a petition for rehearing is filed, and there have been a couple of occasions I've seen the court rule on a petition for rehearing the next day. Sometimes it may take a while. If it's not filed, more likely than not, the court then has to issue a mandate, and that would essentially terminate that action before the Supreme Court. By court rule, the court has discretion to issue the mandate within 7 days of whenever the deadline for the petition for hearing passes, or the court rules on a petition for rehearing. So if that were to occur, if no petition for rehearing was filed, that would put the mandate could be issued on or about March 2nd, 2026, which would essentially result in that case being over before the Oklahoma Supreme Court. We did get, if you look at the Economic Development Agreement, which was passed in conjunction with that ordinance creating TIF districts, Section 8.5A is similar to what you would call a force majeure clause. Essentially, it allows a party, if there's certain events that occur that result in a delay, there are a number of deadlines that are set forth in that Economic Development Agreement. The one that was most pressing when this was submitted was, if you guys recall, we approved the phasing plan. That was one of the first deadlines. The second deadline was for the developer parties to submit development plans, which would have been much more detailed sort of plans with regard to how that arena and parking garage are going to be constructed along with the infrastructure. That deadline would be, it was 90 days before the beginning of construction, and construction was scheduled to begin on January 1st of 2026 of this year. So the deadline for submitting development plans 90 days before that would have been October 3rd, 2025. On October 3rd, 2025, we received this notice under 8.5A from the developer parties, essentially indicating that they were exercising their right under this 8.5A provision to delay the performance of them with regard to those development plans. And they specifically said that they wanted to delay the time period from the beginning of the litigation, which was November 18th, 2024, through the date that it was resolved by final non-appealable ruling of the Oklahoma Supreme Court. So if I calculate that time period from November 18th, and we're going to assume that the mandate is issued on March the 2nd of 2026, that is 496 days. Now, I don't know that the developer parties intend to delay their obligations under the EDA for that time period. I probably need to sit down with them. I've looked at it from the perspective of, if you gave them a delay period from the beginning of when they were supposed to start construction, which is January 1st, 2026, through the end, through that time period in March when maybe the mandate is issued, that's 60 days. So if you back that up 90 days, their date to submit the development plans would have already expired. If I take it from October 3rd, 2025 through March 2nd of 2026, that's 150 days. If I take that back 90 days, that would make their development plans due sometime in early May. So we'll probably need to get with those parties to talk through, do you really want the 496 days that you talked about in your notice, or is there some shorter time period that you guys need to get this up and going? Because I'm fairly certain they're going to want to get moving sooner rather than later, and they're not going to take that whole 496 days as they've requested in this notice that they sent on October 3rd, 2025. So that's the issue with regard to that particular case. That's what we anticipate going forward. There's been some questions raised about submitting the ordinance to the voters. If you guys remember, initially, before the ordinance was actually passed, we did a resolution proposing to send it to a vote of the people. That was challenged judicially, and the court ultimately ruled that that ordinance was not enforceable, that we could not send, quote, an advisory. There was no legal authority for us to send an advisory, to request an advisory vote from the electorate. And then, of course, you had the referendum petition process. Unfortunately, that ended again, and the court saying that the gist was insufficient. So the question has been raised now, does council have the authority independently of those processes to send that ordinance to a vote? The issue for us is, and when we looked at this, and we looked at it again prior to the ordinance actually being passed by council, essentially what the law says is cities and towns have no inherent power or authority, but possess only and can exercise those powers granted in express words or necessarily or fairly implied or incidental to the powers expressly granted. And that's a 1972 Oklahoma Supreme Court case, essentially telling us in order for us to exercise authority, it has to be expressly stated somewhere in words, or it has to be something that's fairly implied or incidental to those powers expressly granted. In 1983, the Oklahoma Attorney General authored an opinion that essentially says to hold an election the authority to hold an election must come from a statute. So it can't be just, we think it's a great idea to have an election, it has to be a statute. In that particular AG opinion, the question involved the legislature had enacted a sales tax provision that allowed the county to essentially hold an election that would have imposed a sales tax countywide. The effective date of that statute was 1984. A county was proposing to have an election under that provision in 1983, and a legislator requested an opinion from the Attorney General's office, and essentially the Attorney General said, no, that election cannot be held prior to the effective date of that statute. So what that's telling us is there has to be some statutory authority for us to be able to hold an election. And if there is no statutory authority, then essentially if we called an election and it was challenged judicially, more likely than not, the court's gonna rule that the city does not have the ability or have the authority to call that election. We looked at the Local Development Act, and that's 62 OS Section 850. The Local Development Act, in terms of creating a tax increment financing district, recognizes initiative and referendum rights, and those, of course, are the powers reserved to the people under the Oklahoma Constitution to propose legislation by initiative or to repeal legislation by referendum. The statutory provisions in the Local Development Act do not provide the authority for a municipality to independently submit a TIF ordinance to the voters, whether prior to or following approval by the municipal governing body. So when we're looking at that issue, when we're looking for statutory authority, there's nothing in the Local Development Act that gives a municipality the ability to submit, again, a TIF ordinance to the vote, whether it's prior to or after it's actually passed by the municipal body. But we didn't stop there. Municipal attorneys spend a lot of their time in Title 11 of our statutory provisions. Those are the provisions that generally apply to cities and towns. Chapter 1 is the municipal code. Article 16 specifically governs municipal elections, and 16102 states, the provisions of 16101 et sec of this title shall not apply to any municipality which is governed by charter. So all those provisions that talk about elections in Title 11, since we are a charter municipality, this statute is saying those don't apply to you. So the next thing we would go to look at is to see what our charter says. Our charter does have provisions with regard to elections, and what it says is the general election laws of the state applicable to cities are hereby enforced except as modified herein. So the modifications in Article 2 of our charter apply to elections for elective office. There are no provisions that would apply to elections for other issues that may come up before the municipality, such as tax increment fining districts. But this provision, Section 21, tells me that now I need to go back to the statutes, because even though the statutes say they don't apply if you're a charter municipality, our charters say, oh yeah, by the way, yeah, they do. So you need to revert back to what the statutes say, specifically in Title 11, Article 16. What did they say about questions such as tax increment fining districts? Well, Section 16-112 specifically talks about special elections, talks about questions that may be submitted by the municipality, and it says when the municipal governing body shall deem it advisable, it may, by resolution or ordinance, authorize the mayor to call a special election on the date established in Section 3-101 of Title 26 of the Oklahoma statutes for the purpose of submitting to the registered voters of the municipality the question of issuing municipal bonds, of granting any franchise, or for any other purpose authorized by law. So, under our charter, which refers us back to the provisions under state law, this authorizes the municipality to call a special election for municipal bonds, granting of any franchise, or for any other purpose authorized by law. And the issue that we're talking about doesn't involve any of those questions. We're not issuing bonds, we're not granting a franchise, and the next question would be, is there any other statutory provision anywhere in the statutes that you could look to say, submitting this issue to a vote of the citizens is authorized by law? And the answer takes us back to where we started, which is the Local Development Act, which again does not provide statutory authority for a municipality to independently submit a TIF ordinance to the voters, whether prior to or following the approval of a municipal governing body. So we end up back where we started. Essentially, there really isn't any statutory authority to submit that ordinance to a vote of the people, whether it was before, like we attempted to do before, which again, that was litigated and the court ultimately ruled that the municipality did not have authority to call that election, or following. It has to be by referendum if it follows. It could be by initiative before the ordinance was passed, but again, this issue that we're talking about was a referendum, and that was attempted. Unfortunately, it wasn't successful. And our position is that we do not have the authority to submit that to a vote of the people currently.
Yes.
So, before my time, there was a charter review committee, and they had talked about putting a vote to the people for TIFs over a certain size, if memory serves, to a vote of the people. So, why didn't it come forward in 2022? Was this the reason, like why they held off recommending it advance?
If one of the things that is authorized by law to send to the vote of the people are charter provisions. So if that was a recommendation that was being made to amend the charter to provide for that, that would have been something that's authorized by law, because the provisions in Title 11 do authorize charter elections. So when you're amending your charter, like we're going to do here in the very near future, that would be something authorized by law. But if you take that outside the charter context and it's just an ordinance, that's not authorized, unless it's a bond or a franchise or some other. I mean, I know taxing measures are authorized by law. There's some other specific issues that are authorized by law that municipalities can put to an election. This just isn't one of them.
So do we know why they didn't advance it forward, the other charter amendments?
I do not know. I mean, apparently it did not receive enough votes either from that charter review committee, or that particular council did not schedule an election for that particular measure.
So if we were to put it in the charter, then you could, in theory, have the public vote on it before the Local Development Act comes into play?
I want to pull my hair out a little bit, at least what I have left. It probably is something that you could do, and the only hesitation I have is, remember the provision that says, in Title 11, that says, if you're a charter community, it doesn't apply, but then our charter says you go back to the state statute. So to the extent that it might take some massaging of some of that language to make sure that you're not creating a set of circumstances where you put it in your charter, but your charter also says you have to refer to state law, and state law says you can't.
Okay.
So, yeah.
Interesting. Thank you.
Oh, yeah. So that ultimately is our opinion with regard to whether council has the ability to submit that to a vote of the people just independently without either going through the referendum process. We've also talked about the issue of, what if council just repealed the ordinance creating those TIF districts? I've gotten this question multiple times, and there've been some instances in the past where some council member will ask me, well, can we enact an ordinance and prevent a future council from repealing it? And the answer is no, you cannot. You can enact whatever you think is appropriate, but you don't have the ability to bind future councils with regard to enacting or repealing a particular ordinance. But that doesn't necessarily mean that repealing legislation acted by a prior council will not have consequences. There may be some occasions when you do enact legislation, and as a result of enacting that legislation, there are going to be some potential consequences if that legislation is subsequently repealed. It's come up recently with regard to the issue of zoning. Once council enacts a zoning ordinance and a particular citizen relies on that zoning ordinance, if a subsequent council were to repeal that zoning ordinance, that particular property owner still has the right to develop their property under the repealed zoning ordinance, it's something that's called a lawful non-conforming use. So even though you had one council enact it, you had another council repeal it, the consequences are the property owner who can rely on that, has the ability to rely on that, notwithstanding the fact that it was repealed. If this were repealed, I would anticipate the first thing that's gonna happen, or one of the things that's gonna happen, is we're probably gonna get some sort of a legal action that's based in part on Article 1, Section 10 of the US Constitution, and that's what's called the Contracts Clause. And the Contracts Clause states, is applicable here, no state shall pass any law impairing the obligation of contracts. And we'll talk a little bit more about what that means in a second. But we also have a US Supreme Court decision that says a municipal ordinance is a state law within the meaning of the federal Constitution. So when it says no state shall, it could be no municipality shall pass any ordinance impairing the obligation of contracts. And essentially what that means is if a municipality is part of a contract, if the government is part of a contract, if at some future point in time, a subsequent iteration of that governmental entity decides we don't like that contract and they want to pass a law outlawing it, this prohibits you from doing that. The government cannot essentially get itself out of its contractual obligations by passing a subsequent law that has a negative impact on whatever their contractual obligations were. In this case, which comes from the Federal Court of Claims, which is in DC, it specifically says a state cannot by repeal of a statute relieve itself of a contractual obligation. This case that we cite, that's the C also, which is Brown versus Crummer Investment Company of Wichita, Kansas versus City of Florida. In that case, what happened is that city, that municipality enacted a street maintenance bond. And it did it there were assessments. So we're gonna come in and we're gonna improve our streets. And in order to pay for that, we're gonna put assessments on the property or of the street, the properties that front that street that are receiving the benefit of that street improvement. People purchased the bonds, the municipality paid off the bonds for a limited time, and then a subsequent iteration of that municipal governing body decided, we don't wanna pay those anymore. So what they did was they went back and said, well, we went back and we looked at our records and it doesn't appear that there was a quorum of our governing body that was available at that council meeting. So we're gonna say that that ordinance is invalid and therefore we don't have to pay off the bonds. And the court in the case said, yeah, you do, because under the Contracts Clause, you cannot, by repeal of a statute, relieve yourself of contractual obligations. So what we have in terms of our case is, more likely than not, because we have an economic development agreement of which the city, the Tax Increment Finance Authority, the county trust, and the landowners are all a party to, and because that contract has provisions in it with regard to assisting in development financing by creation of those tax increment financing districts, it's gonna be really difficult for us to repeal the ordinance and then come back and say, hey, by the way, we don't have to pay the developer parties, specifically the county, for the arena and the parking garage, those tax increment financing revenue, because we repeal those ordinances. If that were to happen, we're likely gonna get a lawsuit. It's probably gonna have a breach of contract claim. It's probably gonna have a claim for violation of the Contracts Clause. We talked before about this in terms of what is the measure of damages with regard to contract actions, and generally it's the difference between what you were supposed to get and what you didn't get. And here, I would anticipate at a minimum, those parties are gonna be saying, we're supposed to get $230 million, and so that we can construct this arena and parking garage. As a result of repeal of that ordinance, at a minimum, we're not gonna get that. So we're looking for damages that would total, at a minimum, that amount. And remember, for claims under Section 1983 for violations of the federal Constitution, you're also entitled to your attorney's fees. So that plus whatever they thought their attorney's fees would be, but at a minimum, I'm using the $230 million number. Judgments against municipalities in Oklahoma can be paid from existing fund balance or put on the ad valorem property tax rolls and paid over a 3-year time period with interest. I'm fairly certain that we don't have $230 million laying around that we could use to pay for a judgment. So more likely than not, what would have to happen is you'd have to put that on the ad valorem property tax roll, again, paid over a 3-year time period with interest. Talking to our finance department, I asked them, I said, give me, if we had a $230 million judgment that we had to place on the tax rolls, give me what the first year payment would be for houses valued at $100,000, $300,000, and $500,000. And for a $100,000 house, the first year assessment for that judgment would be almost $2,000. If you think about it in terms of, I think the way that my mortgage works is the amount that I have to pay in taxes is put in escrow over that 12-month time period and then paid at the end of the year. And the way that this procedure works under state law for municipal judgment, the first payment is due a year from the date of the judgment. So you've got time for the county to calculate what your tax payment is going to be, communicate that to your mortgage company, and then they're going to start charging you pro rata over a 12-month time period what they believe your tax liability for that year is going to be. So more likely than not, for a $100,000 house, your mortgage payment is going to go up by about $159. If it's a $300,000 house, your first year payment's $6,000, so your mortgage payment is going to go up about $507,000. For a $500,000 house, your first year payment, your first year payment is a little over $10,000, which would be an $855 increase in your mortgage to pay just that assessment over that time period. So we probably would not be recommending repeal. There's another issue that goes along with this, and we've been playing with this in my office because it has some implications and some other issues that we're going to discuss in the future. And that is the potential conflict of interest, because not only are you guys council members, you're also the trustees for the Tax Increment Finance Authority. And generally, there isn't an issue with regard to those particular functions that council members hold, or those two offices. But an overlapping service in those two areas really isn't inherently unlawful. There really isn't anything unlawful about those. And there is no automatic statutory conflict of interest merely because the same individuals serve in both capacities. The difficulty becomes if action you take in one capacity impairs contractual rights or obligations in another capacity, that's when there may be potentially a problem in terms of conflict of interest. If it repeal repairs contractual rights or harms trust interest after reliance or benefits private interest connected to the official, then the fiduciary responsibility as trustees and potential ethical issues become real litigation risk. So we've talked about that we've talked about it. I don't know that anybody really has brought it up that I know about, but we have talked about that potential difficulty as it relates to this particular issue that you be looking at, again, because the city and the Tax Increment Finance Authority are both parties to that economic development agreement, it does present some potential risk with regard to conflict of interest, especially if an ordinance is repealed that subsequently prohibits the Tax Increment Finance Authority from being able to discharge its obligations as essentially the project manager. I mean, the Economic Development Agreement specifically designates the Tax Increment Finance Authority as the entity that's responsible for pursuing that, for pushing that project forward. So it does create some issues there, and I don't necessarily want to oversell them, but I also don't want to overlook it. Because potential conflicts of interest with regard to fiduciary obligations does potentially carry the risk of personal liability. So that's something I don't think you can overlook. But with that.
Yes. I was gonna ask, how did that conflict work the other time when another council had to unwind out of the first year PTIF?
The issue there was it was done by agreement. So it wasn't the city unilaterally repealing the ordinance. It was an agreement between the city, the Tax Increment Finance Authority, and the property owner that eventually unwound that TIF. It reduced some of the the available funds for development of that process, but again, that was by agreement.
So if we were to get into a situation where the general fund is suffering and we had to unwind, then we're not in conflict because the other entity be like, oh, there is like a massive impact and we're seeing potential furloughs or whatever.
Yes, as long as you did it by agreement, there's no conflict.
Okay.
Councilmember No Fire?
So could you educate me on why, if we were to repeal it, it would be the full 230 million versus what they've already spent as far as damages that they could sue for?
Well, remember, the 230 million is just my estimate. I don't really
Yes.
know. I mean, that would be a discovery issue. I mean, you'd have to go forward and find out what have you spent and, you know, what it was spent, what should we be responsible for in terms of breach of contract damages? And I'm just, because I don't know at this point what they've spent.
You're just doing the full amount? Oh,
Yeah.
Got it, okay.
Just to say, I would expect them to, at a minimum, ask for that much. It's probably would be
I'm sure
more
they'll
than
try
that.
for it.
Yes, but just for purposes of discussion, at a minimum, I would anticipate it would be that much.
Councilmember Bruce?
I'm just trying to follow the conversation when unwind prior agreement, and we're talking about UNP.
Yes,
Okay, I'm just trying to understand that when we say unwind, that agreement was fulfilled, right? The bond was able to be paid off. And that,
correct.
okay, well, it's paid off. Let's,
Well, my understanding is because of how well that performed, it was paid off sooner than we anticipated. So there were some outstanding issues. We wanted to reduce and actually eliminate the tax increment diversion. But there were still some outstanding obligations that we had under that EDA. So in order to sort of terminate that tax increment finance provision early, we entered into an agreement with the parties to the EDA where we all agreed that we would end it as of this date. I mean, you weren't here for that. There was, not too distant past, there was an issue about, there were still about $5 million available for the developer if he attracted certain kind of businesses, which he believed he did. Council wasn't sure whether he did. There was some litigation with regard to that. Ultimately, the court said, yeah, we think he complied with that particular term, so he was able to obtain those particular incentives. So there were some incentives left over, but we had stopped the actual tax increment diversion.
I'm a little slow, Rick, I'm sorry.
That's okay.
Okay, so to me, okay, they're carrying bonds, the bonds are paid off, we're done. That should have been a trip hold, one of the many different trip holds were done.
It could be,
Okay,
yes. The bond part is done, but you still may have some outstanding issues with regard to incentives that they may be entitled to, that you can end the increment early, but they would still be entitled to some incentives.
I understand.
And, yeah, part of that was a part of the original development, the Lifestyle Center was pretty much agreed upon that that wasn't gonna get built the way it was envisioned. And so they needed off the hook for that obligation.
Right.
And we wanted to end the increment early so we could return those funds to the general, or get those funds going to the general fund. And so, that was the negotiated agreement that was made, was we could forego that, whatever remaining funds were for that incentive that was supposed to be for attracting something new to Norman, new and unique to Norman, and walkable too. And, but yeah, that took about a year of negotiation to come to that agreement then. And then this one, Councilmember Bruce, is about council's ability to repeal this new one for the entertainment district and whether that's even a viable option as people have inquired about, so.
I'm fully following it,
Okay,
more than what you know,
awesome.
just because of my background in contracting.
Oh, yeah.
So we've had an example of, in Bethany, where they're voting on TIF somehow. Are you familiar with how that happened and how does that work? Given the state law and the Local Development Act and charter, and I don't know if Bethany's a charter city either, so.
Talked a little bit with the Bethany City Attorney about that issue, and essentially, they've amended their charter, my understanding is to prohibit any incentives from going to private developers, which would not just be TIFs, it would be anything. One of the questions I had for him, and he didn't really know the answer, was because the Local Development Act allows the voters to propose a tax increment finance district by initiative, if you have a charter provision that says, no, you can't do that, isn't that arguably a violation of those citizens' constitutional right to propose that legislation by initiative? And his response was, we didn't think about that. So I understand that they've done that by a charter amendment. And again, that would be something that you could put to a vote of the people. You can put a charter amendment to the vote of the people. So doing it that way is how they did that. But I'm not totally certain they really thought through all of the potential problems that you might encounter legally with that particular provision.
And I was trying to think of, I lost my train roll for a minute. Is there any other questions I might think of? It might come back to me. It was about Bethany. Okay, there was discussion before about even if we voted to amend the charter to vote on TIFs, that the local election board may refuse to call an election for that, citing state law. Even if we said it, they might not hold an election.
That is another possibility. We have talked about that, haven't crossed that bridge yet, but that is another possibility. The question becomes, for me, when you look at the provision in Title 11 that says any other purpose authorized by law, what does that mean?
Yeah.
Does it mean a purpose authorized by state law, or does it mean a purpose authorized by your municipal charter? So that would be the question, I think, that somebody would have to answer at some point in time if you had that sort of fact set up. May require some litigation. Again, don't know how the court would rule one way or another, but that is a possibility. Even if you have it in your charter, if it's not something if it isn't something that the legislature has authorized you to do by law, there may be an argument that you couldn't do it if it was in your charter, and the election board may say, we're not gonna do that, which means we'd have to go sue them to try to see if we can get the court to agree that our charter provision should be considered authorized by law under that provision in Title 11.
And we don't know if Bethany's had a vote on, if they've actually voted on a TIF project or anything.
I would say the answer is probably not.
So they haven't tested.
Yeah, I talked to the Bethany City Attorney. We have our OAMA, which is Oklahoma Municipal Attorney Association. We have a spring and fall conference. And Catherine and I made a point of tracking him down to ask him those questions when we were at our last conference. And like I said, we talked a little bit about it. He wasn't necessarily, didn't think about the issue about the initiative part. But he did not say anything about them having one, so I'm going to assume that at that particular point in time, they probably didn't.
They didn't.
And in the memo you'd sent us, you mentioned a part about council member personal liability, and I think there was some concern about that, depending on what decision we made about this.
That has to do with the potential conflict of interest. That's the concern I have about if you repeal the ordinance, is there an argument that you can't use your position as a council member to impair your obligations as a trustee, and whether or not that could potentially lead to a conflict of interest that could result in personal liability?
Can the NUA trustees convene an NUA meeting and repeal the ordinance as NUA trustees, not as the city council?
No, because the NUA trustees don't have the authority to enact an ordinance. I mean, only council has that authority.
And if council does it as council, that creates another conflict.
That could create that possibility.
Okay. Any other comments or questions for Rick or staff? I know the petitioner's attorney is here as well. If there's any questions for him about their side of things. And the part you mentioned about mandate or petition for rehearing, what does that include? If that is submitted, the Supreme Court takes it up again, and it might take a month or two.
Yeah, like I said, I've actually, petitions for rehearing, essentially, if in your opinion, there was some error in the court's opinion, its reasoning, its conclusion, that you wanted the court to sort of revisit, you do that by petition for rehearing. I've literally seen petition for rehearings ruled on the next day after they were filed. I've seen them take months to be ruled on. If I had to guess, because this case was up there so long, I'm assuming that they probably discussed every word that's in that opinion to some extent, and it was an 8-1 decision. So the likelihood that a petition for rehearing would be successful probably diminishes based on those circumstances, based on the length of time it was up there, based on the fact that it was an 8-1 decision. You would essentially have to convince 4 justices to reverse their vote. That likelihood is probably, that's a difficult hill to climb. I mean, it doesn't mean it can't happen, it's just difficult. And again, some attorneys believe in filing petitions for rehearing, some don't. We've had the opportunity to do them on occasion. Had success in one of them. I actually have a case where we prevailed, the other side filed a petition for rehearing, and the petition for rehearing did address an error that the court made in its decision. Essentially, it said, in your decision, you concluded that a particular document wasn't in the record. Yes, it was, and here is where it's located. So we want you to revisit your conclusion based on the existence of this particular document in the record. And the court granted the petition for rehearing and said, you're right, there was a document in the record and it doesn't support your position. So here's another opinion that incorporates that, you still lose. So, I mean, it just depends. That mechanism is out there. And what's really important about it for us is the court's not going to issue a mandate at a minimum until after that 20-day time period for petition for rehearing runs, because it wants to give the party the opportunity to file a petition for rehearing if you want to. So we're going to wait that 20-day time period, and on day 21, if you haven't submitted a petition for rehearing, then we'll look forward to issuing the mandate. And that will tell us this case is over. You can move forward with whatever it is you need to do based on our decision.
So from the developer standpoint, do they have to wait to issue bonds, or the county authority? Do they have to wait until that mandate's issued before they can actually do anything?
I wouldn't suppose they have to, but if I were their attorney, I would tell them you probably need to, just out of an abundance of caution. What's the difference between, issuing them on February 4th versus issuing on February 20th? It's a risk. It's a little bit of a risk. I mean, not as big of a risk as it was before the opinion was issued, but it's still a risk.
I've heard 30 days can cost $30 million. Okay, let's see. And then next steps, if the Supreme Court decision stands, if there is no other thing in the way of it going forward, what would council's next action or role be in this whole process going forward?
We probably need to get together with the attorney for the Keeling County Trust and the landowner to talk about how we're going to go about amending some of the deadlines in the economic development agreement, because again, I know a number of them have passed. I know that the date for commencing the infrastructure construction for the arena and the parking garage was January 1st, 2026. Obviously, that's come and gone. And again, they requested a delay of 496 days. I really doubt they're gonna want that much time period. We're gonna have to sit down with them and say, okay, tell me when you guys wanna start, because that's going to trigger when their development plans are due. They have to submit their development plans to the Tax Increment Finance Authority 90 days before they commence construction. So we're gonna have to figure out the next thing I think we're gonna have to do is figure out some of the deadlines.
And council would have to vote to allow those deadlines to be amended? Because then I would ask what happens if council does not
Well,
do that, of course.
I think it's the Tax Increment Finance Authority that has to do that. the council is part of the EDA. So yes, council probably would have to agree to amend those, but the issue is reasonableness. If council comes in and says, we're not gonna agree to any deadlines, I suspect we're gonna end up back over in district court with the other side saying that's just unreasonable. There clearly is an 805A that allows for delay under such circumstances such as litigation. There's no doubt whatsoever that there was litigation involved. We exercised our option under 8.05A to request a delay. That was acknowledged. Now we need to move forward with some amended deadlines. If the city is just sticking its foot in the sand and saying we won't agree to anything, that's probably gonna result in litigation.
Councilmember Novire.
Just out of curiosity, since he is here, I was wondering if the defending lawyer is going to file a petition for rehearing to start off.
That's a matter to discuss with my clients and the organization. I think
Okay.
Councilor Knighton gave you a fair summary of the issues there and what would happen. I do have comment to make about the substantive presentations given tonight. And it is up to council if they want to check their emails. I will be providing that in writing. I can provide you a summary right now if you wish, of some of the issues.
I would personally like it if that's possible. Good with it and.
First of all, I would say as to the issue of repeal of the statute, the city attorney neglected to mention the Local Development Act statute directly on point. That is, if you give me just a moment, I'll pull it up. It'd be cool if we could pull it up here. It's 62 OS 856C. And I'll preface this by saying part of the reason I'm here tonight and part of my background is I was very much down in the dirty of this very issue with UMP TIF 2 and the amended project plan and the evaluation of the arguments there. Section C of that statute provides, notwithstanding any provision contained in an ordinance, resolution, or project plan, an ordinance or resolution establishing an increment district shall constitute a legislative act and may be repealed, modified, or amended at any time during the term of the increment district. That means year 1, year 6, year 17, year 23. When you repeal it is very relevant to the contracts clause argument. The only major exception is if bonds, as we heard in the contracts clause analysis, if bonds are outstanding that are issued pursuant to Article 10, Section 35 of the Oklahoma Constitution. You go on OSCN, that little thing will link you right to Article 10, Section 35 of the Constitution, and the type of bonds they are describing there are a type of bond authorized by the vote of the people. How ironic that City Council maintains the plenary, broad, virtually absolute authority to repeal a TIF ordinance under the Local Development Act unless bonds that have been issued by a vote of the people are outstanding. I think you'll find that's what's going on in the contracts clause case that was cited there, is it was too late to be repealing the ordinance under the contracts clause. What I would say about the contracts clause argument, just as we dealt with, and I was actually dealing with the developer side on this one with TIF 2, was that argument was made back then, and that argument was made in the context of TIF 2 being performed for years and years and years. Development agreements that were valid, that were undoubtedly valid, had been performed for years. Projects had been completed, projects were underway. There were millions of dollars in increment funds in the increment fund pot. There are none here. There are no projects enacted. The increment hasn't begun. Now is the time that can be done without minimizing the risk of a loss in a contracts clause case. Now, what generally happens in a contracts clause case? The party seeking to invalidate the city or governmental action that substantially impairs the obligation of contracts usually seeks injunctive relief, declaratory relief, and what that means is they come into court and they say, hey, they can't do this. And the first thing a judge does in that type of a case is the judge, as he did with the resolution election case that happened a few months ago, the judge says, can they or can they not do this? If the judge says they can do this, there is no $230 million judgment to send to the jury because the judge has just validated your action. If the judge can't do this, again, it is highly likely there is no issue of a $230 million judgment to send to the jury because what the judge has just done is said, you can't do this. And I have made this equitable ruling. I have made this ruling as a matter of law before we would send this $230 million judgment request to a jury. And therefore, you have to go through with the TIF. And all these issues get resolved before we send the issue of monetary relief to a jury, which a jury of Cleveland County decides. A judge doesn't enter judgments for $230 million. A jury does that. If there is injunctive or declaratory relief sought, a city can come in and say, hey, judge, you have to decide this issue before we get to the issue of monetary relief. So to me, it's you repeal the ordinance, you take action to send it to a vote, you get sued. Yeah, you're going to get sued. There's two things that are going to happen. Just like happened the last time a former council tried to send this to an election. A judge is going to say either you can or you can't repeal the ordinance. A judge is going to say either you can or you can't send this to an election. And if the judge says you can, there's no $230 million judgment because the judge just ruled what you did was legal. If the judge says you can't, there's still no $230 million judgment because the judge just put the TIF back in place before you ever got to the point where you had to decide the developers were going to lose any money. So yes, they're going to sue you. They're going to include money. They're going to include a prayer for relief for all kinds of money judgment. But it is a substantially implausible outcome in this case that monetary relief would be granted to anyone because it would be a matter of do you or do you not have to do this TIF? Can you or can you not send this to the election? Now, on the election issue, I would say that an analysis of Article 2, Section 9 of the city charter needs to be done. I didn't see that up there, just like I didn't see an analysis, I didn't see a mention of the Local Development Act. And what I would say about the Local Development Act is if you read that statute, the drafters of the Local Development Act, you can tell they had this contracts clause problem in mind when they did this. What they said, if you read that statute, you will see that they set up a regime that kind of addresses the issue of is a city substantially impairing the obligation of contracts? And that's only first element of contracts clause violation. You also have to show that there's nothing the city could have done to advance its legitimate interest other than what it did. So when you look at substantial impairment, baked into the statute is kind of a contracts clause safety valve analysis of saying, well, you can repeal it, but you can't repeal it once these bond issues come out. I would also add something that I've added to the city before, to the council before, which was there's an issue of whether the economic development agreement is even valid in the first place. The council that enacted the ordinance also enacted the economic development agreement on that very night. The problem with that is the ordinance was not in effect for another 30 days. Our position, and we feel it is supported by statute and local Title 11 and the Local Development Act, is that in order to enact a valid economic development agreement, there must be a valid TIF ordinance in effect. In other words, you have to pass the legislation has to be in effect. If you look at the project plan, if you look at the ordinance, that absolutely sets up a situation where what was needed was to wait until the ordinance was in effect before you could adopt a valid economic development agreement. That again would be an argument to the city available against a contracts clause argument. These are things, I'm gonna tell you, no court has decided this precise issue. No court has had this case in front of it. But you do have a statutory path for repeal that is extremely broad. And I think an analysis needs to be done of Article 2, Section 9 of the city charter on the ability of this city to send this to a vote of the people by ordinance, not by resolution like last time. That was something that wasn't gonna work. Not by resolution, but by ordinance. And I think more needs to be done as far as analysis of those two things. And you know our position on it.
Thank you, Mr. Norman. Councilmember Grant, do you have a question? Okay. Any questions for staff
Is
following that? Councilmember Hinkle?
Mr. Rieger gonna be allowed to give his side's position? Was he invited this evening to speak to council?
It is open to anybody, and he could be here. Okay. For our city attorney, the question about the ordinance being passed and then the agreement, economic development agreement being passed the same night. Argument about it needed to be in effect, which would take 30 days if we didn't pass it by an emergency, which we didn't. Is that somewhere,
First time I've
or
heard that.
maybe you need to look at it?
Yeah, first time I've heard that, so
Okay.
we can take a look at that. and give you a
That
response.
was something that caught my attention for sure. And the part about if bonds had not been issued, so that was part of my question about the issue of a mandate. If there's not a petition for rehearing, if they issued bonds, it would be hard to reverse it at that point, I would think. As far as
Well,
like
one of the
damages
things that's
go.
missing from that sort of analysis is we totally skipped over the issue of breach of contract. The plaintiff controls the litigation. So what I would anticipate both a claim under the contract clause and a claim for breach of contract. Assuming what you heard is accurate in terms of the ability to ask the court to rule on declaratory versus injunctive relief first, the other side is probably just as smart as we are, and they probably would avoid that by just not alleging a breach of contract cost claim. You could just allege a breach of contract claim, and that would carry damages and an award from a jury. So what I think I want you guys to take from this is there's risk. There's legal risk. You can take the legal risk, you cannot take the legal risk. What you've heard from both sides is more likely than not, if you repeal the ordinance, you are going to get sued. And maybe you'll prevail, maybe you won't prevail. There's that risk out there. And if a particular council is willing to take that risk, we'll do everything that we can to make sure that we're put in the best position that we can be put in. But there's also the thought process of you don't have to take that risk.
Any other questions or comments from council for city attorney or staff in general? Comments? Okay. Well, I would encourage everybody to think about all of this. There might be a few outstanding questions about the ordinance versus the economic development agreement. If that's a factor or not, I would think it'd be pretty big if it was invalid because of that. That would be interesting. And if you have any thoughts on next steps about this, what you'd like to do, I would let city manager and city attorney know your preference on all that. Are there any final comments or questions about this from council? Okay, then we'll look forward to the next update and seeing what happens on the 23rd. If there is a petition for rehearing.